circumstance to the crime of copyright infringement. So,
Okay, so far it's not, we cannot say that it's infringement if we download music illegally from the internet. Is that the case? Or not necessarily?
well, it with the incorporation of these provisions of this from the internet treaties, it would now be easier for copyright holders
To hold them liable.
to hold them liable, and in fact, it would make the penalty higher. Because if we only have copyright infringement, then under the law you would have only so much penalty. So it could range from it depends on how many times you committed the copyright infringement. However, if you violate a technological measure under this version of the bill, then the judge will consider that circumstance surrounding that illegal downloading, that infringement, as an aggravating circumstance, which means it increases the penalty.
So if you go around this particular measure, the encryption, or you were able to crack the
That's right. Yes, if you're
password,
a techie and you were able
and
to break through the barrier, then your crime could aggravated. Yes, that's right.
Okay, so for all of us out there downloading music illegally, we can be held criminally liable under this amendment. Okay, so how about the other measure that you were talking of, the digital
there's also it's called rights management information. Rights management information are information which identifies the work. So who is the author of the work, who produced the sound recording, who was the performer, and any right in the work. And it also contains the terms and conditions for the use of the work. So if ever these information which are embedded in the work which is disseminated in the internet are altered, so somebody altered the name of the author or the name of the performer or the publisher, then he could also be liable under the law. Again, in the same manner as the violation of technological measures, under this version of the bill, they would serve as aggravating circumstances to the crime of infringement.
Okay, so there are instances wherein there's a work uploaded on the internet, be it a song or maybe a book file, a PDF of a book, and of course there's an indication there of the author, the publisher. Those are the rights information, more or less. And if a person is able to alter that, those information, that's also punishable. It's going to be punishable under
It's going
the law.
to be under this version of the bill an aggravating circumstance.
It's considered it will increase the penalty for the infringer.
That's right.
That's right.
Of course, may I inform our listeners that of course there are other versions of the bill, like there are versions of the bill even in the Senate, which offers another mode of protection of these technological measures. And anyway, this is still subject to debate among the stakeholders in copyright.
So at the moment, what is the status of the bill? Is it in the in the Senate already?
Well, in the lower house, in the House of Representatives, it is now up for plenary. So we were just waiting for the schedule of the plenary session, and the sponsors of the bill will sponsor it on the floor, maybe a few weeks from now. In the Senate, they're still in the technical working group level.
Okay, so that's the status of the copyright amendment bill. Okay, first, an announcement here. The Intellectual Property Office of the Philippines will be holding a free seminar on trademarks this coming Friday, February 11, at the Intellectual Property Office of the Philippines, located along Buendia Street, Makati City. Pre-registration is required. Please contact Ms. Bing Del Valle at telephone number 752-4869. Now, for those interested to learn more about copyright, do join us for a free seminar next Friday, February 18 at 1 p.m. also in the IPO. Again, contact Ms. Bing Del Valle because pre-registration is required. Her telephone number is 752-4869. And for those of you who'd like to join the conversation or you have a question on intellectual property and copyright, please call the studio at 895-4460. Joining me this morning is Attorney Louie Calvario from the Intellectual Property Office of the Philippines, and we'll discuss more about the Copyright Amendment Bill after this short break for BBC News.
We now return to Piracy Watch on DZRJ 810 AM, the voice of the Philippines. Here is your host, Sarah Jane Sigitan.
Hi, welcome back to Piracy Watch. Retailers could be in for a rude shock if they attempt to use Kate Middleton's name to sell replica products for clothing, according to royal aides and legal experts. Despite nothing being official in place yet, any label or brand which uses Kate Middleton's name to sell merchandise risk being sued for infringing trademark and copyright laws. A royal aide said, "It is highly unlikely that we would have any objection if a company wanted to call a dress the Kate dress. Kate isn't specific to Catherine Middleton. It may, however, be a different scenario if it was called the Catherine or Kate Middleton dress, as that impacts on personal copyright." Okay, moving on to Harry Potter. Judge zaps a copyright claim over J.K. Rowling. In J.K. Rowling's Harry Potter and the Goblet of Fire, ruling that stark differences separated the fourth book in Rowling's best-selling series from Adrian Jacobs' 1987 book about an adult wizard's quest. U.S. District Judge Shira Scheindlin found no overlap between Goblet of Fire and Jacobs' The Adventures of Willy the Wizard. Jacobs died in 1997, but the trustee of the late author's estate, Paul Gregory Allen, filed the lawsuit against Rowling. Okay, this morning I'm being joined by Attorney Louis Calvario of the Intellectual Property Office, and we're discussing amendments to the existing copyright law, particularly the problematic areas of copyrighted works downloaded and uploaded illegally on the internet. Again, Attorney Louis, can you give us a summary of what can be foreseen once this bill has been passed?
So once this bill has been passed, then we would have a Bureau of Copyright within the IP office, and we would have incorporated the salient provisions of the WIPO, the WIPO Internet Treaties, which will help us enforce the copyright of rights owners over the internet. And in addition, the amendments will also give the IP office the power to accredit and regulate collective management organizations.
When you say collective management organizations, they perform the same functions as managers to artists, performers, right?
Well, they are like in other countries they're called collecting societies. They're the ones who enforce the economic rights of the authors, meaning, like, for example, the right of reproduction or the right of public performance of the work. So they're the ones who go after the users of copyrighted works, ones who reproduce or publicly perform these works, and they would give the just or equitable compensation, which we call royalty, to their member authors or artists.
All right, for artists or musicians particularly, they should be left free to their creative process. That's why they usually hire managers or join collective management organizations to take care of the performances or the rebroadcast.
That's
of
right.
the
It depends on what right that a specific author or writer has assigned to the collective management organization. Like, for example, for music, composers usually assign their right of public performance over their work. So if, for example, a certain composer has a song which is publicly performed in many public commercial outlets like restaurants
or bars.
So he joins now a collective management organization. In the Philippines, it's the Filipino Society of Composers, Authors, and Publishers, or PhilSCAP, and the PhilSCAP will be the one who would negotiate and run after the users of the music, and he would negotiate the terms and conditions, and specifically the royalties that would have to be paid for the use of the musical work.
Are there other collective management organizations for performing artists?
There are, yes. We have one for writers and publishers.
For book authors.
For book authors, yes, which we call PhilCalls.
PhilCalls.
The Filipinas Copyright Licensing Society. We have one for visual arts. They've just started, which is called Filvadro, the Filipino Visual Arts and Design Rights Organization. we have one for performers, the Performers Rights Society of the Philippines.
Okay. So far we have 4, and all of you artists, authors, painters, and writers out there who have a hard time policing your work, or in terms of monitoring how many times it appears or how many times it is played over establishments, you can join this collective management organizations, and they will be the ones to keep track of how many times your work has been played or used or aired,
Used.
and collect the
The corresponding
concomitant,
royalties.
royalties. Okay, so when this law is passed, the IPO will accredit
Would have to accredit all of these
all of
groups.
this. So the IPO will play a sort of regulatory function in terms of making sure that these organizations are not only promoted so that they will have more artists to protect, but also that they will perform their functions, duties under the law for the copyright
That's right,
holders.
yes.
Okay, so will there be, is the criteria for accreditation already laid out, or will that be left to the discretion of the IPO?
Well, the IPO will conduct a public hearing on that matter.
On the criteria for
Yes, that's
accrediting?
right. On specifically on the IRR, or what we call implementing rules and regulation regarding the accreditation process with the IPO.
Okay. So, but if I am, for example, a private manager, do I need to apply for accreditation, or will you only accredit organizations? Only organizations.
Well, we do not distinguish
Understood.
whether or not it's an organization or whatever group.
Or
It's
a person.
or a person. The law says person, entity, or organization.
Okay, so managers out there can also seek for accreditation. That way, you have a direct link with the only government agency, primary government agency dealing with copyright,
Intellectual
which is the
property,
Intellectual
yes.
Property Office of the Philippines. Okay, are there other points in the amendment bill that the public needs to know? This is more or less a public hearing for you, Attorney Louis.
Well, we have special provisions for the visually impaired and the blind.
The blind.
It actually gives them a special fair use exemption for the non-commercial reproduction of works used by visually impaired or blind people.
Last Sunday I was invited to speak in the first Business Law Students National Summit in the
Of
Ateneo.
Ateneo.
Yes, and one of the questions that the participant was a dean of the Ateneo de Zamboanga University. She was asking me if there is copyright infringement for teachers who require their students to photocopy pages from books. And of course, I discussed the idea of fair use, which is more or less an exemption to copyright. See, copyright, it means that only you can control the use of your work if you're the author. But there is such an exemption under the law called fair use. And among the forms of fair use is academic use. Is that correct?
Yes, so one of the purposes allowed for your act to be considered as fair use is for teaching.
For teaching.
That's
for
right, and
academic.
for research or scholarship. However, we'd like to inform the listeners that there are also conditions which have to be satisfied or met in order that this act or this purpose would really be characterized as fair use. So, first of all, what is the purpose of the work? Will it be for personal purposes or commercial purposes?
By commercial, we mean we make multiple
Like
copies
you
then
may
for profit.
for profit, that's
For
right.
profit,
Then
for
what is the
profit.
nature of the copyrighted work? Then how much was copied, the amount and substantiality of the amount copied.
Of the amount copied.
Like if you copied the entire work and you commercialized it, then it's no longer
fair use.
fair use.
It
And then
doesn't
the
fall
last
under
one is the effect of the use on the potential value or market of the work. So in other words, if that act which is purportedly fair use will in the end potentially affect the market of
Okay,
the
that's-
author, so nobody buys the book of the author anymore because it's already available in the
Photocopied
classroom,
form, yes.
photocopied form. Then even if the purpose is
Academic
for
or
academic
teaching.
and research purposes, then that would take that out of the ambit of fair use,
Fair
and it
use.
could be infringing. No?
It could be infringing. Again, it is not fair use if the copying is commercial and it doesn't meet the four requirements of fair use, which means number one, what is the purpose of the copying? Number two, the substantiality or the amount copied.
And what is the nature of the
The
copyrighted work?
nature of the copyrighted work, and lastly, if it hurts the commercial